Good morning. My name is Len Foy, and I am a real estate attorney in Nashua, New Hampshire. For those of you who have been following me on YouTube, I have made a number of videos. We have produced a number of videos, and we are broadcasting a number of videos concerning real estate attorneys in general, and my office in particular. The services that we offer clients, my history in this profession, in this industry, tips for people buying and selling real estate, title insurance, deeds. So anyone who's interested can see a full catalog of different videos that we have been producing over the course of the last several months, with myself as the star, of course. And today I'd like to talk a little bit about best practices. Now, a few housekeeping matters. You'll see that I'm dressed somewhat casually. That's because I am in the process of surviving a New England winter, which is of biblical proportions. So rather than wear a suit to work and have all of my clothes completely destroyed before I've even walked through the front door of my office, just in the course of cleaning off my car and trying to get through 3 feet of snow to get to work, I'm dressing the part, and of course I have no real estate closings and no client appointments today, so I can get away with casual attire. But most people who know me know that I'm fanatical about my dress, and I normally wear a suit and a tie and the rest of that stuff. I'm going to try to keep this video somewhat short. I think if I've made any mistakes, probably I have erred on the side of making my videos too voluminous, too lengthy. I think they're so rich with information. I really would encourage people to check them out and to watch them. I think you'll enjoy them. I know that you'll find them to be very informative. But lengthy videos are more difficult to watch, so I'm going to try to err on the side of brevity today, keep this tight, concise, and hopefully just as informative, but without all the fluff. So the subject of today's video is going to be best practices. What people might say, well, what are best practices? Well, really, they're just that. Best practices are a number of practices, or the manner in which a company does something, I guess to boil it down into its simplest terms, that the title insurance industry is demanding all of its members, participants, title companies, law firms adhere to. So I think as I go through these best practices, it'll be more clear and more understandable to people what they're all about. Importantly, and I have some reading material here which I don't normally do, it's just to keep myself organized, because these best practices, although they're near and dear to my heart and they're part and parcel of this law firm, they are still somewhat part of our sort of recent understanding of what this industry is demanding and what people in this industry have to offer clients and customers. So the first point that I want to emphasize, which I think is so important and which is so satisfying to me when I first incorporated the best practices into my law practice and my title company operations. First of all, I'd like to point out that many title companies and law firms are just now starting to incorporate and implement so-called best practices into their business models. I was asked by a lender back in 2013, so several years ago, 2013, around this time, 2 years ago, I was asked by a lender to codify our best practices, follow the established template. We did that. We were able to stay on their approved attorney list, approved title company list. So I guess what I'm most pleased about is that these best practices have already been a part of the fabric of these companies for several years now. And even before we knew about best practices, before we heard about best practices, these things were already a part of our daily operations here. I think they're part and parcel of running a good business and running a clean business. So I don't marvel at them. I'm not complaining about it. I'm not surprised about it. It's not a pain in the neck to implement it. It really is the way we've been doing things around here since the day I opened my doors. But nonetheless, it's now official and we all need to honor it. So the first best practice, so-called, is, and I know this of course, establish and maintain current licenses. First of all, this is as axiomatic as anything I've ever heard or read about, and yet it never ceases to amaze me. Attorneys that are suspended, I read about it all the time, and it's embarrassing, and I certainly don't want to be in the position of casting any aspersions upon anybody, but we've all read about those attorneys who have allowed their licenses to lapse. They've been suspended for failing to pay their dues. They've been suspended for failing to attend continuing legal education courses. I knew of another professional in a different profession who had allowed that to happen to herself and tried to justify it. Look, as attorneys, we are expected to be masters of detail. How can we be masters of detail if we can't even master the detail of keeping ourselves currently licensed? Which last time I checked involved nothing more than filling out a form and sending in a required fee in a timely manner. So, but nonetheless, all of our licenses are current and good standing. That includes law licenses, that includes insurance department licenses, that includes licenses to be a settlement agency, which are required in the state of Maine. So with all of the 4 states where we operate, New Hampshire, Massachusetts, Maine, and Rhode Island, I can assure you it is no small feat to maintain our licenses. It's a lot of bureaucracy, it's a lot of red tape, it's a lot of fees, and they all fall due at different times. So we always have to be on the lookout for when is our license going to expire. We need to fill out the form, we need to send in the check. We've always been on top of that. That's never going to change. Escrow trust account controls. We have all, and again, I hope this doesn't come across as bragging, because it's not really in my nature to brag or to boast, but I feel, I think, a justifiable sense of pride that when I read about these best practices and I hear attorneys sort of running around and complaining and stressing out because of best practices, and I read through them and I think to myself, I've been practicing law for 20 years and these are always the things that I paid close attention to. Even 20 years ago, when I was in my 20s, I mean, I'm an old man now, but when I was in my 20s and I didn't know what I didn't know, I knew that I needed to keep an eye on my trust accounts. I knew that I had to do everything within my power to make sure that my law license never lapsed, never expired due to non-payment of fees or failing to attend a continuing legal education course. Again, this is like basic organization. I mean, I don't think that you need to be a genius to be a lawyer. God, I hope you don't have to be a genius to be a lawyer, but I think you need to be organized. And I think part of being organized is knowing, okay, my fees are due by a certain date. Okay, my accounts, my escrow accounts, my trust accounts, my IOLTA accounts. IOLTA is an acronym for Interest on Lawyers' Trust Accounts, IOLTA. These accounts have to be in good shape. So anyways, not only do I go through the accounts painstakingly, and not only do other people in this office, we have complete transparency within our office as to these accounts, so that all of our senior people have access to them. Not only do our title insurance companies go through these accounts exhaustively to eliminate the possibility that there's ever any impropriety of any kind, but we actually utilize the services of a professional accounting firm to audit as an additional layer of protection, transparency, scrutiny. And we've done that for years. So I'm not some, with all due respect to competitors who may have organized their offices differently than the way I organized mine, I'm not some lawyer that's up until 3 o'clock in the morning trying to reconcile my own accounts, hoping that I got it right. I'm part of a team of professionals. We're all going through the accounts. We're monitoring them constantly to make sure that there's no fraud, that everything is right, that the right money has gone into the right account. So that's something that we do. Best practice number 3, physical and network security. Another thing that I feel a lot of pride about. I've worked for other lawyers. I've worked for the good, the bad, and the ugly, and everywhere in between. So I've worked for top-flight law firms that had the best of the best of the best. And I've worked in smaller firms where it was, it wasn't quite, shoestring and bubble gum, but it was definitely more of a bare bones operation. We have always erred on the side of expense and investment in having a server, in having backup, in having network security, in having a professional firm. We actually utilize the services of a professional firm to maintain all of our information technology, and we have for years. So we have a disaster management plan. We have all this stuff. We've had all this stuff for years. So again, I feel a lot of pride that these best practices, which were intended to be groundbreaking, which were intended to be trailblazing, all they really did was reinforce in my mind that part of the reason why my firms have been successful is because we made these investments on day one. This was part of getting, these practices were no different than getting a phone number, finding where our office was going to be located. I guess what I'm trying to say is that these things were important to me as anything associated with opening my practice, and have been for years. So information technology and the security of customer and client information are paramount, and they've always been a part of the way we run this firm. So people who use us can have a level of confidence that their information is protected, because it is. Recording and pricing procedures. And again, I want to keep it positive. I don't want to be, I don't want to cast aspersions upon my competitors, but it never ceases to amaze me. I had a client that was interested in the way one of their closings had been handled, and in the course of doing some due diligence and some investigation, I found out that the attorney that they'd been working with was notorious for recording documents, mortgages and the like, a month and a half, 2 months after the closing, which we can do a separate video on that, but that's just completely irresponsible. It's probably a violation of agreements that attorney has entered into with their title insurance companies and with their lenders and with their clients and other parties. Documents need to be promptly recorded so that if you close on a mortgage associated with a sale, the documents are recorded that day, next business day, not a month later, not 2 months later. And if you do a refinance where you have a 3-day right to cancel, obviously documents are not going to be recorded within the cancellation period, but they are promptly recorded at the expiration of the cancellation period. Pricing controls. We've all heard of attorneys that have different pricing for different clients. That used to be permitted in our industry, unfortunately. Or back in the bad old days of subprime and the mortgage meltdown, I think we knew of firms that had extraordinarily high pricing on subprime mortgages, I think because there was a perception that you could get away with it on those transactions, with more moderate pricing for people with good credit, A-level people, whatever that means. Those days are over. I think we all adhere to uniformity in our pricing across the board, across different lenders, different types of borrowers, different situations. Our firm is no different. All of our pricing is available. If you just call our office, you can get all of our pricing sent to them. We're completely transparent. There's no secrecy. There's no mystery about our pricing. And of course, the recording of documents is something that we do. We have established policies for that. We follow those policies scrupulously. Again, we could do an entire video segment on it, but when documents are not properly recorded, and when I say properly recorded, I mean a few different things, including timely recorded, it allows for intervening matters or items to be recorded against the property and essentially dislodging the priority position of the document to be recorded. So that if a mortgage is supposed to be recorded and isn't, it's recorded a month later, it could be within that month that something else is recorded, like a lien or an attachment, in which case that mortgage is in second position or in a subordinate position to the lien or attachment that was recorded first. So there's a priority in recording, and so any attorney that is recording documents when they get around to it, as opposed to immediately, is taking a tremendous risk on behalf of their clients, and it's improper for them to do so. Policies and premium remittance. So every attorney or title company, or a lot of them, struggle with this. So everybody's in a big hurry to get the deal and do the closing and pay themselves, and then the files find their way into a back office where they stack up, and the policies don't get prepared. Policies, that being title insurance policies, owners and lenders title insurance policies. Lenders title insurance policies go to the lender. Owners title insurance policies go to the owner. All of the policies go to the underwriter, whether it's Chicago Title, Old Republic, First American, Caddick, Stewart, whatever the title insurance company is involved. Some attorneys rely on professionals from those title insurance companies to come in and, quote, help them with their policies. We make every effort to do our policies as part of our post-closing procedure. So we don't have files going into some back room and stacking up for policies to be done, or files going into a back room waiting for the policies to be done. We are doing the policies as we are closing out the files. So we're sending out payoffs, we're recording documents, we're scanning everything to our server, and we're generating our policies, and we're remitting our policy premiums. So and that's always been the way we've operated. Maybe during the busiest of busy seasons, there'll be a little bit of lag, but at the very first opportunity that we have to get caught up and stay caught up, we do, and we take care of it. Maintaining the appropriate professional liability insurance and fidelity coverage. This is also quite basic. If you don't maintain these coverages, you will not be able to get business in this industry, because even the most lackadaisical of lenders, and there are some lenders that have a very minimalist approach to vetting their closing attorneys, will require this type of insurance. So we have always had this kind of insurance. Going back to the first practice that I opened, the very first practice that I opened, which I'm very proud of, I opened in the San Francisco Bay Area. It was the law offices of Leonard Foy and Foy Law Firm, these two firms. And insurance at that time was not mandatory, but of course I got it, and it made all the sense in the world to me to have it. I don't know that there have been any times throughout my professional practice when I did not have this kind of insurance in place. Again, I view it as very basic, very fundamental. And it surprises me that there are still attorneys out there that are not insured. Of course, they're not in the real estate business if they're not insured. But I'll hear about sole practitioners who can justify and rationalize not having insurance. I've heard people say it makes you a target for lawsuits. There's a lot of ridiculous arguments floating around out there. The bottom line is that you just need to have this kind of insurance. And a fidelity bond, we have that. A lot of our competitors do not, because it's expensive. Fidelity bonds can range anywhere from $3,000 to $4,000 to $5,000 to $6,000, $7,000 annually. It covers a variety of things, including employee theft and employee dishonesty. Some lenders, like Bank of America and Countrywide before them, require it. We have one. I'm very proud that we have one. I know of competitors that do not, because they didn't want to make the investment. We've always made those investments. The opening of my law firm was an investment. And we invested in everything associated with doing that, whether it was a matter of getting a service and an IT professional to help us, enlisting the services of an accounting person to help us keep the accounts reconciled constantly, getting the appropriate coverages in place, whether it be E&O coverage or a fidelity bond. All of these best practices, when you read through them, it's all code for investment. And that's why I think a lot of attorneys are concerned about their implementation, because they look at some of these and they think, oh boy, now I've got to go out and get an account. Now I'm going to go get an IT person. I can't use this, this peer-to-peer system that I've been using for the last 10 years. These are investments that we made years ago. So these are this is the way I opened my firm. This was part of our, part of our opening day ceremony, was to have all of these things in place so we could run this firm right. Not just so I could sit here 10 years after the fact and say, hey, we run our firm the right way, but because it's ultimately to the benefit of the people that we are supposed to be looking out for. We don't have problems in our accounts because we have professionals involved. We don't have security breaches and lapses and disclosures and our system getting hacked into because we have the right people involved. I've never been sued, and I hope I never am sued, and I'm going to knock on wood just to make that official, like any Irishman would. But I've never been sued. But if I ever was, I would want to have that insurance in place. And I've heard attorneys rationalize not having E&O coverage like it makes them a target in a lawsuit. How about the fact that if somebody loses money because of a lapse in judgment on your part, they can't get compensation because you rationalized not getting insurance? I mean, insurance is for the protection of my clients. Having a professional go through our accounts is for the protection of my clients. Having an IT person on retainer to maintain a state-of-the-art system is for the protection of my clients. That's why I didn't do all that so I could sit here on video 10 years after the fact and brag about it. I feel a justifiable sense of pride that we did it. But I did it because it's about protecting the people that we're supposed to be protecting. That's why I did it. Adopt and maintain procedures for resolving consumer complaints. This was the easiest one because rarely, if ever, do we have consumer complaints. And when we do, I jump on them immediately. I never run from that kind of stuff. But we have a process for resolving them. It's codified, so if any of our customers or clients have any grievances or disputes, they can certainly take them up with us and they will be resolved to their satisfaction, even if that means, well, whatever that entails. We do not allow people to come away from this law firm with negative experiences. I won't let it go down that way. It's imperative to me that people be satisfied with our services or that we make some kind of an accommodation with them so that they're ultimately, in the final analysis, they're satisfied with our services. So these are the best practices. And again, you're going to hear a lot about them. We have them. They're in writing. They're available for inspection. They're not secret documents. Obviously, all of our individual policies, whether it's our clean desk policy, our privacy policy, our disaster management plan, these are all proprietary and would not be available for public inspection other to, regulators or the people or our business partners. But the policies themselves and our adherence to them is certainly a matter of public record and available to any customer or client for inspection. My name is Len Foy. I'm a real estate attorney. I like to say that I'm the real estate attorney that does things the right way, which is the way I've been doing things throughout my career, which has been a 20-year career now. It's very important to me, and I take a lot of pride in the fact that I have not been the subject of any complaints. I've never been sued. I've never had these kinds of problems, which might be attributable to not having a network security plan in place, not having account controls over your financial accounts, not having customer information under virtual lock and key, if not actual lock and key, not having a clean desk policy, which has been part of the fabric of this law firm for many years. So this is the way we have always run this firm, and it's the way we always will run this firm. My name is Len Foy. I'm a real estate attorney in Nashua, New Hampshire. Our phone number, if you're interested in contacting our firm, and I hope you do, is 603-598-4030. We're available on the World Wide Web. Look us up, please. It's www.foylawoffice.com. My email address is lfoy@foylawoffice.com. Send me an email. Our fax number, people periodically will fax us documents, 603-598-4020. Again, I'm a real estate attorney, so I would certainly encourage interested parties, whether they be lenders, buyers or sellers of real estate, people who are currently refinancing, give my office a call. I would love to work with you on your next real estate transaction. But separate and apart from being a real estate attorney, I am an attorney who has always made these best practices a part of my practice, and that is what I have to offer clients and business partners. Thank you for taking the time to watch this video. Good luck getting through this snowfall if you live in the Northeast. Have a wonderful day, and please call my firm to discuss any of your legal matters or anything at all. I'm here and available to speak with you at any time. Have a great day. Bye for now.